Kick ass.
What's up, guys? This video is a practical exercise video that we pulled out of our full program and made available for free here on YouTube, which means that there are documents you need to obtain in order to get the fullest possible benefit from watching it. This is a briefing exercise video, and that means that the docs you need are the blank text of the opinion that this video is going to cover, as well as our model book brief version. And to get copies of both of those documents in PDF form, all you need to do is click the link for them in the description section of this video, and we will send them to you. As a general rule, we recommend trying to brief the plain text version yourself before looking at the model version and then watching the line-by-line explanation of the case that follows on this video. To get what you need to get out of your case reading, you got to be able to answer 3 questions about every single case that you read. The first is, what black letter rules or law does the court recite in its opinion? I'm going to kind of breeze through this because we've already talked about it in the intro to case briefing video that we've already done. But the point here is we're looking for rules that either define legal theories or that define the elements or the factors embedded in those legal theories. Those are the most important thing that we need to draw out of the case so that we can write our outlines. Second, we need to look at the inferences about the facts that the court whose opinion we're reading invokes as it's analyzing the rules that it recites. And I do want to say this. If there is a factual record to which the court refers, then we need to take a look at the facts that they invoke, see what inferences those facts support. Occasionally, the court is going to talk about what inferences are possible based upon the universe of facts that's in the record. Sometimes they're going to talk about what inferences would or would not be possible based upon the posture of the case. And sometimes they're going to talk about what facts are missing and what kinds of inferences they would either support or negate. But regardless of how we characterize the exact posture of those inferences, we need to look for what do they say about whether or not these rules are satisfied in light of the inferences that the facts in question support. Okay? And then third, we need to be able to answer the question, who got what? The point here is, if somebody wins, then by definition, all of the boxes are checked in their legal theories. The facts and the law are on their side. By the same token, if they lose, there by definition has to be a defect in their argument somewhere. So where is the hole, either the legal or the factual hole in that person's argument? If we can answer who got what, even if the court doesn't necessarily tell us how it's resolving the issues, we can deduce a lot about the viability or not of the particular legal theory coupled with the particular facts adduced in evidence. Okay? So those are the 3 questions. Let's just briefly go through my highlighting scheme. Again, we've already talked about it, so we're not going to belabor the point. I want to be able to get into the text proper of our case. I just want to review here so you know exactly where we're at and what we're doing before we actually jump into the text. So let's just rehash the basics of my highlighting color scheme for book briefing. Remember, we're not writing out full briefs. We're highlighting the case as we read it so that we can bring our case with us to class and know where to look to find the information we know we need based upon any question our professor happens to pose to us during that process. But also, we're highlighting in a certain way so that we can go back to the case and know exactly where to find all the rules it recites so that we can fold those into an outline. Okay? So key facts, we do those in yellow. I try to use that sparingly because yellow doesn't show up that well. But key facts include whatever facts are necessary to help you understand the relationship of the parties to the lawsuits, plaintiff, defendant, exactly how they relate to what's going on. And key facts also help you understand the strengths and weaknesses of the litigants' respective arguments. Now, I'll just say this, be sparing with key facts. There probably aren't any more than 5 key facts in the narrative portion of your case. And by the same token, if you start highlighting everything in yellow, then, the value of highlighting diminishes accordingly. At any rate. So pink, we do procedural history. And what we're looking for here is the ultimate disposition of the matter currently before the court whose opinion you're now reading made at the levels below. Okay? And we're not really looking at reasoning so much as result. Sure, the court may recite what the trial court thought about what it did or what the appellate court thought about what it did, but we're looking for what those courts did, what they actually did, the disposition. So did a trial court grant or deny? Did a court of appeals affirm or reverse or maybe remand? We're looking for those dispositions in our procedural history. So I'm always saying trial court, highlight, grant or deny, highlight. That's what we're looking for. Related to procedural history is going to be the ultimate issue, and I highlight that in pink too. And what we're looking for here is, what does a court whose opinion you're currently reading say is the ultimate issue it's got to consider? Now, it is true that whatever the court says about its ultimate issue doesn't often happen to be the issue that you actually care about for the purposes of class discussion or for the purposes of your exam. However, the way that the court frames the issue is going to clue you into some procedural nuances potentially about how what you really care about is going to play out. At any rate, the ultimate issue is highlighted in pink here because it does connect to procedural history. You know, trial courts grant or deny, courts of appeals affirm or reverse or remand. And they do those things based upon the precise contours of the question that they're called upon to examine. And that's maybe not going to make so much sense to you right this second, but after we read a couple of cases, I think it'll click for you. So I highlight that in pink as well. Once we're moving into the content proper of the case, when we're looking for black letter rule or law, I highlight those in blue. And the rules are the guts of the case. They're what your reading is really all about. So we're looking for every rule we can find, whether that's a rule recited for a broad legal theory or for one of that legal theory's discrete components, whether that's, whether those components happen to be elements or factors. Now, here's the key thing. The rules that the court recites imply what the real legal issues in the case actually are, okay? So if the court is reciting a rule for a legal theory, then that is one of the raw issues in the case. If the court is diving into the rules or the law for some of that legal theory's elements or factors embedded in the legal theory, those are issues as well. So next, we're going to look for either analysis or application. We'll highlight that in orange. Analysis or application includes discussion about either the key inferences that the court draws or could draw or says could be drawn from the facts, and how those inferences relate to the rules that the court's already mentioned, okay? So analysis to me, I don't want to play a semantic game here, but I just sort of break it up and I think of analysis as facts and application as, law tweaking. So the second thing we're looking for here is where the court is considering which of several possible rules to apply to maybe a novel situation. We want to know why it picks a particular legal approach or definition for a rule if it has options, okay? So analysis is sort of like, what inferences can we draw from the facts? And the facts are the thing that's moving and the rules are the thing that's static. When we're talking about application, the rule is the thing that's a moving target. The facts maybe don't change. They maybe stay static. And what influences the outcome of whether the rule for a moving part or a legal theory is satisfied or not is which approach to a rule, which definition for a rule the court elects to use. Okay? So anyway, we're looking for either one of those things, and we're highlighting them in orange, whether it's a factual or a legal controversy. All right? And then I'll highlight the ultimate holding in pink. And this statement, which usually appears near or at the end of an opinion, is basically the mirror image of the ultimate issue that you already highlighted in pink. And by comparing the ultimate holding in the case and its procedural history, comparing that to the ultimate issue that the court already stated, you can usually work out who got what, even if the court does not explicitly answer that question on its own. And then lastly, party-sponsored arguments I highlight in green. And basically, whenever a party urges the court to embrace a particular view of the facts or of the law, sometimes judges are going to mention that in their opinion as they're sort of analyzing all the different pieces in play. The reason I highlight this in green is I always want to be sure that I'm not mistaking party arguments for the court's own reasoning. Just because the court mentions what somebody argues doesn't necessarily mean that the court adopts that view of how either the facts or the law should be characterized. So it's often very useful to visually distinguish whatever text recites a party-sponsored argument, just so you don't confuse it with the court's own reasoning. Okay? So at this point, these are the highlighting conventions, and we're going to jump into the text of the case here in just a second. Okay, so our case is Bazley v. Tortorich, and we're going to start off, you're going to see here, with mostly procedural history, ultimate issue, and holding. It's all going to be grouped together at the beginning of the opinion. So here we go. This case presents the question of whether the workers' compensation statute constitutionally makes compensation an employee's exclusive remedy for a work-related injury caused by a coworker, except for a suit based on an intentional tort. Now, anytime you see the word whether, automatically you know this is ultimate issue language. In terms of the big question presented, almost always, especially if the case is a little bit older, you're going to see it set off by whether or not such and such, right? So here what the court is basically saying, if I'm saying it a little bit more clearly, is something like the following. If an employee's coworker does something that so I'm going to try and say this a little bit more simply. If an employee's coworker injures the employee, the question is, can that employee do anything other than invoke the remedies of the workers' compensation statute? Can they get money any other way? And what this is, the question that this court is asking is, can they do it in any other? And the question that this court is asking is, can an employee use something other than the workers' compensation statute if the coworker who hurt them didn't commit an intentional tort? That's basically the question. So now the court's going to launch into the procedural history, and they're going to tell us what lower courts decided about all of this. The trial court sustained an exception of no cause of action to plaintiff's suit against his fellow employee because he alleged that the coworker was guilty of negligence and not an intentional tort. So the trial court dismissed. Why did the trial court dismiss? The trial court said, look, plaintiff, you've alleged negligence. You have not alleged an intentional tort. There's no case in tort here. The only remedy you've got is the workers' compensation statute. That's the only way that you're going to get money based upon this injury. So the Court of Appeals, what did they do? Well, they looked at this next, and the Court of Appeal reversed. So they undid what the trial court said. They're saying basically to the plaintiff, your lawsuit is no longer dismissed. We're reinstating it. So the Court of Appeal reversed, holding that to afford due process and equal protection of the laws, the workers' compensation statute, as amended, must be interpreted to permit an employee the same remedy in tort against co-employees for negligently caused work-related injuries as he would have if injured by any other tortfeasor. So that's a long way of saying the Court of Appeals didn't think it was constitutional that an employee be confined to a workers' compensation remedy. They think that he should be able to sue in tort if it's a coworker, just the same as he would be able to sue in tort if some other third party not affiliated with his employer had harmed him. Okay? We, meaning the Louisiana Supreme Court, who is now reviewing the opinion of the Court of Appeal, so we reverse the judgment of the Court of Appeal. The workers' compensation statute was amended by such and such a law, and it precludes employees from recovering from their coworkers for any work-related injuries which they sustain unless those injuries result from an intentional tortious act. Now, one thing I want you to see here is this is the ultimate holding statement. The Supreme Court saying we're reversing the Court of Appeals, which by definition means that they're actually, by default, affirming the trial court's dismissal. And then they're saying, look, the statute precludes you from recovering unless your coworker hurts you through an intentionally tortious act. And we could highlight what's highlighted in blue in pink. That would be fine. I'm just highlighting it here in blue because by right of the fact that the court has stated this the way that it has, this is a fair statement of the law. And I've set off, the words reverse and Court of Appeal in pink So I know that even though I'm sort of highlighting this in a rule sense kind of way, that this is the ultimate holding. I've clued myself in enough by highlighting things this way. So here we go. The 1976 amendment does not deprive the plaintiff of due process of law, equal protection of law, or access to the judicial process. And here, all the court's really doing is they're doubling down and they're saying, look, there is no constitutional problem with giving the plaintiff only a workers' compensation remedy in this instance. There's no constitutional problem with eliminating his resort to tort theories for legal redress. So that's basically all of the procedural history at the very beginning of the case. And at this point, you know a lot of things. You know who got what. And how do you know that? Well, the trial court dismissed plaintiff's lawsuit, so plaintiff got nothing. Court of Appeals reversed the trial court and said, no, we think there's enough here for the lawsuit to continue. We don't want these tort theories thrown out. Supreme Court says, no, trial court got it right. These tort theories are no good. So what you can work out from that is, in this case, plaintiff gets nothing, defendant wins. And by nothing, I don't want to make it sound like the plaintiff doesn't recover. I'm just saying the plaintiff does not recover on tort theories. The only thing they get is workers' compensation. That's what this case is saying. They're saying only workers' comp. They're saying only workers' comp for you, plaintiff, no tort. So the next thing we're going to talk about, the next section of the court's opinion, is going to be its recitation of the facts. All right, so now we're about to get into the facts. And as you're going to see, this court writes really confusingly about the facts. I'm not even going to bother reading through this particular piece of the case. Basically, if I were highlighting this, I'd be highlighting the plaintiff as Sidney Bazley. I'd be highlighting who Sidney Bazley sued. Namely, he sued an unidentified co-employee truck driver along with various insurers. And I'm not even really sure of the lineage of these insurers, okay? But the point is, the root of all these insurance entities is Bazley's coworker, all right? And one thing that I just want to point out here is this last clause, as a result of work-related injuries Bazley received when he was struck by Tortorich's car while he was mounting the back of a parish garbage truck. That clause, because it uses the passive voice, is really unclear. When he was struck, meaning Bazley, by Tortorich's car. See, that makes it sound like his coworker was driving some kind of garbage truck and actually hit Bazley. I don't think that's what happened. Or it's possible that another motorist who just happened to be on the street that particular day and was in a collision with the garbage truck that his coworker was driving was also insured somehow by Tortorich. That doesn't make any sense to me, and the court would do well in this instance to tell us more of the story. You know, was Bazley riding the garbage truck and another motorist struck him? Was he hit by the garbage truck? The court should be more clear here. At any rate, I don't like highlighting in yellow, and it doesn't show up especially well on the screen, so I'm going to move on quickly. But just so you can see, I'd be highlighting the parties in yellow and what the essence of the lawsuit is. But that's about all the yellow highlighting that I'm going to do. All right? So on to the next piece of the facts. So Bazley alleged that the accident was caused by his co-employees' intentional acts. And one thing you need to know here is anytime you file a lawsuit, the complaint is going to be the document. You're going to make various factual and legal allegations. So this case clearly was dismissed based upon the pleading, not actually based upon like a jury verdict or a motion for summary judgment. So what you need to know here is the standard for dismissal is what has the plaintiff alleged in his filing document. And let's just assume that it's all true, absolutely all of it. And let's ask the question, okay, so what? Is there any law that even if he proved every single thing that he's alleged in this complaint would entitle him to the remedy that he wants? So Bazley alleged, he said in his complaint, that the accident was caused by his coworker's intentional acts. All right? What kinds of intentional acts in his fact section of his complaint did Bazley allege? Well, he alleged that his coworker was operating a garbage truck without a working horn, that he disregarded mechanical and electrical maintenance standards, that the horn hadn't been kept up, that his coworker failed to keep a lookout, that he failed to see what he should have seen when he was driving, that he failed to stop in a safe place, that he failed to warn plaintiff of danger. Like, all these allegations are what make me think that Bazley was riding the back of this garbage truck when another motorist struck him. It doesn't sound like his coworker ran him over or backed into him while they were on a garbage stop or something like that. At any rate, this is what Bazley alleged. All these different acts. And he's calling them intentional acts. Let's see if the court agrees that they are or not. And that's another reason why, I've highlighted this in green, just so that we can set off the fact that this is what Bazley alleged, not necessarily a conclusion that the court has embraced. Bazley did not allege, so here's some facts that are about to be missing from his complaint, however, that his coworker desired the consequences of his acts, namely that Bazley was struck, or believed that the consequences were substantially certain to follow from his coworker's acts. All right? So those key factual implications or inferences are missing from what Bazley alleged in his complaint. So that really sets the table on the facts we've got. So when we start thinking through the facts and inferences that are applicable to the rules at issue, this is where we're going to go. We're going to look for the orange, and we're going to know, okay, what we're looking for are the inferences that these facts will support. Now, granted, these are allegations of fact. So what the court is going to be looking at is, could these facts support any inferences that the law Bazley's invoked applies? All right? So it's not quite, which inferences are the good ones. It's what inferences are possible based upon the factual allegations that Bazley has made. All right, and with that, we're going to start jumping into the law proper. Dipping a toe in. Okay, so now we're going to get a brief introduction to the overall legal theory just before the court's heading and all the analysis that's going to follow here, okay? So the next portion of the opinion reads, the Louisiana statute, revised statute as amended, provides, quote, "The rights and remedies herein granted to an employee on account of an injury shall be exclusive of all other rights and remedies against his employer or any principal or any officer, director, stockholder, partner, or employee of such employer or principal." So the general rule for our broad legal theory here is workers' comp, the statutory scheme established therein for work-related injuries, is an employee's exclusive remedy. So ordinarily, the general rule here is tort liability is unavailable to an injured employee. The next part, though, is going to give us an exception. Nothing in this chapter, meaning the chapter spelling out workers' comp liability, shall affect the liability of an employer or an employee of such employer resulting from an intentional act. So that phrase there, intentional act, in the statute is what's going to define the universe of our controversy here. And I've highlighted all of this in blue because this is a rule statement lifted directly from a statute that the court is reciting in the text if it's an opinion. And it is defining the legal theory in play here. The legal theory happens to come to us from a statute that says, hey, if you're an employee whose coworker injures you, your only remedy, unless that coworker injured you intentionally, is workers' comp, right? So we've set the universe. Now the court's going to jump into a heading talking us through all the nuances of the law, what an intentional act actually means, and it's going to introduce that whole line of argument with a heading. But this is setting the table on the law that we've got to deal with. So the heading here is the exclusive remedy rule prevents an employee from seeking recovery in tort for a work-related injury negligently caused by his co-employee. So here's what you need to ask yourself. Is an intentional act as that exact language appears in the Louisiana Workers' Comp statute, the same thing as an intentional tort. Now, if it is, then because this employee's lawsuit only alleges that his coworker acted negligently, then it should actually be dismissed. The trial court got it right, okay? But if, on the other hand, an intentional act is something less egregious than an intentional tort, then maybe there's enough wiggle room in that phrase to permit Bazley's lawsuit outside of the comp scheme against his coworker to continue, okay? So this heading tells us that the answer to that question is yeah. The exclusive remedy rule is basically going to render Bazley shit out of luck, all right? And what's going to follow in this heading is an explanation of why the answer is yeah, he's out of luck. So just pay attention to the structure of the reasoning. I'm actually going to tell you what that structure is right now because the opinion sort of meanders. So in broad strokes, in this order, the court analyzes first the statute's legislative rationale and history. It analyzes the statute's logical consistence with civil and criminal common law principles. It talks about the comp scheme's general resemblance to the approaches implemented by other state systems. It talks about the incongruities between plaintiffs' preferred interpretation of intentional acts and those other state approaches. And lastly, it juxtaposes the meanings of the legal labels for an act and intent with those that plaintiff wants the court to embrace, insofar as those definitions throw that incongruity into even sharper relief. So it does all of those things to demonstrate why the answer to our question is yes, Bazley, you're out of luck. You can't sue in tort. Okay, so that's going to be the structure of our analysis. And, you should notice one thing about all of those analyses. Namely, they're basically all about the rules. And if you thought, well, gosh, all of those things are about how the rules developed, gold star for you. That is a clue, that's a cue, that whatever the black letter rules are that we're going to collect from this opinion, they are very likely to be in the section of the opinion that follows this heading. All right, so we're going to talk about basically the legislative history of the comp statute in this portion of the opinion now. And the court's going to give us some insight into the problem the legislature was trying to address, the nature of the legal landscape prior to when the amendment was enacted, and give us some insight into what the lawmakers who voted this measure to the governor's desk in Louisiana thought they were doing, okay? And that'll give us insight into what the meaning of the statute is. Okay, so by Act 147, the legislature enlarged the category of employee injuries for which workers' comp was the exclusive remedy. Formally, the comp statute provided that compensation was an employee's exclusive remedy against his employer for a compensable injury, but left him free to pursue other remedies against third persons. So before, comp only precluded tort liability for suits against the employer proper. The amendment, however, modified the exclusive remedy rule in two respects. First modification was, it provided that for an unintentional injury, compensation shall be the exclusive remedy not only against the employer, but also against any principal, officer, director, stockholder, partner, or employee of the employer or principal who was engaged at the time of the injury in the normal course and scope of his employment. So not just the employer proper, but people or parties affiliated with the employer, maybe management or ownership. All right, so that's the first modification. We broaden comp's applicability. We broaden the degree to which it precludes other avenues of recovery, namely tort. Second, the statute provided that for an intentional act resulting in compensable injury, the employee may exercise his right under the Comp Act and pursue any other remedy available against the employer and other persons under general law. So you can sort of picture that there was a little bit of a horse trade here. They broadened the applicability of the comp rule and the degree to which it precluded other avenues of recovery. But by the same token, what they took away, they gave back with an exception for intentional conduct. So the principal legislative aim of the 1976 amendment, so we're getting rationale here, was to broaden the class of defendants to be granted immunity from suits by injured employees in tort or delict. Although the legislative history is meager, accounts indicate that the amendment was enacted to provide employers relief from the cost of furnishing liability insurance to executive officers and other employees. So there's a policy goal here, is basically what I'm saying. And we are going to see this later in the text, but the gist of what it sounds like the legislature was trying to accomplish is they were trying to bring down insurance premiums and litigation exposure for employers for on-the-job injuries. I mean, obviously, if you force people into a comp remedy for their injuries, you're going to reduce employer exposure. But if people can continue to sue people who are affiliated with the company anyway, it's sort of like what the comp remedy is not going to accomplish bringing down litigation exposure if there's an end run that lawyers can exploit routinely, okay? Now, I'm not saying that I embrace the idea that businesses should get this break, or even that constructing a comp system in fact reduces insurance premiums or litigation exposure, but clearly that's the thinking animating this particular measure from the legislature. So before the amendment, the absence of a prohibition against tort suits against co-employees allowed injured workers to seek tort recovery from negligent executive officers and their liability insurers. And this avenue of recovery provoked considerable critical comment. It was argued, and see, these folks are about to make the argument that I just outlined, that since the employer's enterprise would in the end pay for the tort remedy either directly or through insurance premiums for officers and employees, the result would be a denial to the employer of much of the practical advantage of the exclusive remedy provision. It was apparently for this reason that the legislature acted to close this avenue of recovery by adopting Act 147. And in abolishing the executive officer suit, however, the legislature provided that the exclusive nature of the compensation remedy would not apply to intentional acts. So the amendment broadened the applicability of the comp statute, but they didn't apply that to intentional acts. So after considering broader penalties that would have provided double benefits for an employer's violation of a safety rule for failure to provide a safety device required by law or by gross negligence on the part of the supervisory employee, our legislature chose to impose a sanction for intentional wrongs by making the exclusive remedy rule inapplicable to such acts. So they could have made comp more generously compensate employees for certain classes of violations, violations of known safety rules by the employer or their staff, failure to provide required safety devices. Gross negligence is usually a form of negligence that's both extra egregious and involves a risk of death or serious injury. So they could have made the comp remedies more severe for those kinds of things, but instead they chose to create an exception to comp altogether that would allow for tort liability for intentional wrongs. And the reason that's significant is tort liability is going to give you all kinds of forms of damages that you can't get in a comp scheme. You can get pain and suffering. You can get punitive damages, which will often, if you've got a decent case, punitive damages can well exceed double the compensatories here. So it's actually a much stronger remedy than, double damages under a comp regimen. In any event, because of the general practice of severely punishing intentional wrongdoers, which is widely accepted in the field of workers' comp, because of the received meaning and acceptance of the statutory language, and considering the object of the legislation, so yada, 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 legislative history, what we think it means, what we think they were thinking, all that sort of stuff, we conclude that the words intentional act in the statute mean the same as intentional tort in reference to civil liability. Okay, so the court has, they've gone through all this explanation of the legislative aims, the policy goals reflected in the amendment to the comp scheme in Louisiana. Now they're going to put a button on the scene, so to speak. Here's what they're going to say. So in drawing a line between intentional and unintentional acts, we believe that the legislative aim was to make use of the well-established division between intentional torts and negligence in the common law. So, what the court is saying here is, look, these lawmakers, many of whom are lawyers, are aware of the difference between intentional torts and negligence that the common law establishes. And we think that those concepts informed their approach to the comp remedy. So the lawmakers probably perceived this distinction as entirely consistent with the division in civil law between offenses. This distinction, meaning the distinction between injuries compensable under the comp scheme regularly and intentional acts. At any rate, yada yada yada, probably perceived this distinction as entirely consistent with the division in civil law between offenses, which requires an intent to injure, and quasi-offenses where damages are caused without the intention to harm. So universally, harmful conduct is considered more reprehensible if intentional. And as Holmes said, that's Oliver Wendell Holmes, by the way, pretty famous Supreme Court justice who was widely regarded as a very good writer. So as Holmes said, even a dog distinguishes between being stumbled over and being kicked. There's a definite tendency to impose greater responsibility upon a defendant whose conduct has been intended to do harm or morally wrong. So we've just talked about the common law, right? And we've said the distinction between otherwise comp-relegated injuries and intentional acts, it fits with, it accords with, it mirrors the distinctions between intentional torts and common law negligence that the common law already recognizes. So we've talked about the statute's legislative history. We've talked about how the distinction in the statute mirrors what the common law already establishes. Now we're going to talk about the similarity between that distinction, if indeed that's what the legislature did, and the distinctions that other states make between intentional acts and non-intentional acts. So here we go with other states. Many states provide an employee an election to sue in tort or a percentage increase in compensation as the penalty for his intentional injury by the employer or for other forms of employer misconduct. So other states make non-negligence-based recoveries more painful for the employer. Even in jurisdictions with no statutory penalty for employer misconduct, intentional injury inflicted upon an employee by the employer, its alter ego, or in some instances its supervisory employee, may be made the subject of a common law action for damages on the theory that, in such an action, the employer will not be heard to say his intentional act was an accidental injury, and so under the exclusive provisions of the Compensation Act. The reason accidental is in quotes is it's quite likely that some of these state systems provide that a comp remedy covers workplace accidents. And so other courts have not construed the term accident to encompass injuries where somebody intentionally injured someone else on the job. Okay? That's probably what's going on there if I'm reading the tea leaves. Courts in most states imposing such statutory or common law penalties for intentional misconduct have required the commission of a genuine intentional tort. So that would be battery, assault, false imprisonment, intentional infliction of emotional distress, trespass to chattels, trespass to property, something like that. So a genuine intentional tort, and have refused to stretch liability to include negligence, recklessness, or constructive intent. All right, so now we're going to get to, so what the court has just done is the court has said intentional act in the statute is the same thing as we're already familiar with in torts, an intentional tort. Same concept, just different words. That's what makes the most sense to us. Okay, so plaintiff's about to make an argument, so I'm going to highlight that in green. And this controversy is about language from the statute, so I might highlight that in blue or pink. It doesn't really matter because the rules and the issues, as you know, are sort of implicitly connected to one another. So plaintiff ingeniously has proposed, however, that the concept intentional act should be equated with voluntary act. He interprets intentional to mean merely that before the actor acted, he directed his mind on his own physical movement and not on the consequences of his act. Okay, so you can see how helpful it is to highlight this sort of stuff in green. You're not falling for the mistake of thinking that the court is embracing this reasoning. So under his interpretation, an injured employee may sue in tort on any voluntary act setting in motion events leading to his injury, regardless of whether the harm appeared likely or was even apparent to the one doing the acting at all. For example, in the present case, plaintiff contends that he did in fact allege an intentional act triggering his escape from the comp system when he averred in his complaint, that is, made a factual allegation in his complaint, that the defendant garbage truck driver intentionally did not blow his horn to warn plaintiff an oncoming motorist. So the court's saying, look, that's what he argued, and the key fact here is intentionally did not blow his horn. Although plaintiff concedes, so here's the court observing something, that the driver did not intend for harm to come to the injured employee by failing to blow his horn. So we can see the argument there. We can see what plaintiff's trying to argue intentional act should mean. We can see the court considering the plaintiff's contention that his complaint did in fact adequately invoke an intentional act. And obviously the court is expressing some skepticism about that. Plaintiff's interpretation is incongruous not only because it departs from the almost universal practice of differentiating between intentional and unintentional harms prevalent in most comp programs, but also because it ignores the accepted usage of the statutory terms in this state and generally, and his construction would thwart its legislative purpose. So what we can clearly see here is that the court is not going to buy plaintiff's argument that intentional act is somehow different, less than intentional tort. And they're also not going to buy the argument that his complaint alleges an intentional act where it states that the injured employee's coworker failed to blow his horn. All right. And now we're about to jump into the guts of what this case is all about, the rules for intent and act that come from the common law. So let's get to that here. So although the theorists have not always agreed, the words act and intent now have generally accepted meanings in the fields of tort and criminal law. So what's an act? What is intent? Those rules, the definitions for those words are going to be issues, moving parts of a legal theory. So the word act is used to denote an external manifestation of the actor's will which produces consequences. There cannot be an act subjecting a person to civil or criminal liability without volition. So therefore, a contraction of a person's muscles, which is purely a reaction to some outside force, such as a knee jerk, or the blinking of the eyelids in defense against an approaching missile, or the convulsive movements of an epileptic, are not acts of that person. So see, we've got some factual examples of phenomena that don't qualify as acts under the legal definition. The meaning of intent is that the person who acts either consciously desires the physical result of his act, whatever the likelihood of that result happening from his conduct, or knows that the result is substantially certain to follow from his conduct, whatever his desire may be as to that result. Thus, intent has reference to the consequences of an act rather than to the act itself. So here, we've got one thing I want to make sure you understand here is we have two alternate tests for intent. These are not things that layer on top of each other. They are alternate methods of proving intent. So we can, maybe we've got conduct that satisfies the first definition but not the second. We've still got intent. Maybe we've got conduct that satisfies the second but not the first. We've still got intent. It's only if neither test is satisfied by the facts we happen to look at that we can say no intent, at least within the universe of rules for intent that this case has stated. So, we just talked about the common law definitions of act and intent. Now the court's going to pivot to whether those definitions inform other aspects of Louisiana law, and they're going to make a comparison to suggest to them what they ought to do with the comp statute. So our criminal and civil codes manifest legislative acceptance of these received meanings of act and intent. As the criminal code articles and reporters' comments make clear, act refers to an external manifestation of will which must be voluntary, and intent is present when the offender either desires the consequences of his act or when he knew that the consequences were reasonably certain to result from his act. Okay, so basically we can tell that Louisiana has actually pulled definitions for act and intent from its own criminal code to give us the definitions it just stated. Okay, so we can tell that the court has basically looked at the common law definitions for these two terms and has found an almost exact comparison in the Louisiana criminal code to the language that it's used, which is highly evocative about the degree to which the legislatures who ratified this particular comp measure would have been familiar with those concepts, because there are other places in the legislature where those terms are used, and clearly denote parity with the common law concept as it would have been understood at the time this measure came to be voted on. So although the Civil Code does not contain definitions of the terms, the word act is used many times and must be read in light of the code's underlying civilian concepts. So in Article 2315, for example, the word act is used to refer to both offenses and quasi-offenses. And as we noted above, the difference between these two acts of fault is that offenses require an intention to injure and quasi-offenses are committed without that intent. So we can see again a basic distinction between intentional and unintentional acts and the use of intent in reference to the consequences of the act rather than to the act itself. Our jurisprudence, so our court's decisions, not just the legislative history and intent, our court decisions likewise reflect approval of the general notions of act and intent. This court, as early as 1936, recited the following: "It seems clear that in the absence of language expressing a contrary meaning, an act involves an exercise of the will. It signifies something done voluntarily. And only where the actor entertained a desire to bring about the consequences that followed from that act, or where the actor believed that the result was substantially certain to follow his act, has it been characterized as intentional." So here we're going to double down on an attack on plaintiff's argument. So plaintiff's suggested interpretation of intentional act equates the term with voluntary act, not intentional act, and robs it of any reference to the actor's state of mind concerning the consequences of his act. It's most unlikely that the legislature intended the words as plaintiff suggests, rather than their most useful signification, and in the sense in which the lawmakers have used them in other legislation. Furthermore, plaintiff's interpretation would thwart the legislative objective of broadening the class of defendants to be granted tort immunity. Instead, Act 147 would have the reverse effect of restricting the exclusive remedy rule to claims of employees injured without any other person's fault. So what the court is essentially saying here is, look, if plaintiff's definition of intent, which reduces it to basically voluntary acts, is correct, then the exception for intentional acts in the statute swallows the rule, and as a consequence, almost nothing is covered by the comp scheme, because virtually every event that gives rise to employee injury on the job is going to involve the voluntary action of coworkers. So there's almost nothing left that comp covers if that's the definition we embrace. That's what the court is saying, just not super clearly. So the court gives an example. So the court sort of extemporizes further about what the impact of plaintiff's preferred interpretation of the statute would be. So any employee could bring suit and recover under Article 2315 by pleading and proving that his injury was negligently caused by the voluntary conduct of his employer or co-employee. Since there can't be an act subjecting a person to liability for negligence without volition, the exclusive remedy rule, as interpreted by the plaintiff, would abolish all tort immunity for employers and co-employees. So they're saying what I just said, just a little bit differently. In the absence of a clearer expression of legislative design to drastically curtail the applicability of the comp system, we can't attribute such aims to the lawmakers. And for these reasons, we construe the legislation under review as providing that the exclusive remedy rule shall be inapplicable to intentional torts or offenses. So they're restricting the scope of the exception to intentional torts, not intentional acts, because if they don't do that, the exception swallows the rule. The meaning of intent in this context is that, so now they're going to say, look, as a matter of statutory interpretation based upon this case for all time, now intentional act is going to mean as follows. So the meaning of intent in this context is that the defendant either desired to bring about the physical results of his act or believed that they were substantially certain to follow from what he did. So I'm just going to redo reading the text here because I didn't highlight on time. So the meaning of intent in this context is that the defendant either desired to bring about the physical results of his act or believed they were substantially certain to follow from what he did. Several courts of appeal have stated the two prongs of the definition in the conjunctive, thus requiring a plaintiff to prove, in order to recover, that the defendant desired the physical results of his act in every case. Intent is not, however, limited to consequences which are desired. If the actor knows that the consequences are certain or substantially certain to result from his act and still goes ahead, he's treated by the law as if he had in fact desired to produce the result. So the court here is saying what I said a moment ago, like these are alternate pathways to prove intent. You don't have to prove both. You don't have to prove one of them all the time and can prove the other one if you want to. Like proving either definition of intent works based upon your facts is sufficient to satisfy the intent prong of an intentional tort. So applying the statute to the facts set forth in plaintiff's petition, namely alleged in the complaint, we conclude that the petition fails to state a cause of action in intentional tort or offense. The pleadings do not express or imply that the co-employee garbage truck driver desired the consequences of his act or omissions or applying the statute to the facts set forth in plaintiff's petition, that is his complaint, we conclude that the petition fails to state a cause of action, so there's a conclusion from the court, which is highlighted in pink, in intentional tort or offense. And now we're going to get to some factual reasons why the court is again doubling down on that conclusion. The pleadings do not express or imply, that is, they don't explicitly state, and the statements they make do not support an inference that the co-employee garbage truck driver desired the consequences of his acts or omissions, or that he believed the consequences were substantially certain to result from them. So all the factual allegations contained in the plaintiff's complaint, about failing to drive the horn, failing to maintain the electrical systems, failing to drive on the right side of the road, the court is basically saying those facts will not support an inference regarding either definition for intent. And congratulations, that's really the nut of this case for torts purposes. The case goes on after addressing this matter of statutory construction and the meaning of intent and act in the context of the statute when compared against the meanings of intent and act in the common law. But now it's going to move on to a whole bunch of constitutional discussion. And that's really beyond the scope of what we need to get out of this case. If this case were assigned to you in a torts class, once you started to see the constitutional stuff, you could just sort of tune out. Those rules are not going to be especially applicable to you. And so we're not really going to line for line go through the rest of that opinion. We're just going to stop with the explanation here and proceed on to the next case. And you can still read my notes on the case itself. Obviously, you've got it downloaded, you got the clean text, and you've got what I did when I initially went through and briefed it. But that's really more in the nature of curiosity. This is about as far as we need to go for the purposes of our exercise, which is to go through a substantive rule portion of a case and unpack what it's got to say. So remember at the very beginning of this video, we said every time we do a case, we need to answer the 3 questions, all right? So we're going to do that with Bazley v. Tortorich. So what's the first question? What black letter rules or law does the court recite in its opinion? And the black letter rules here, I think you'll see, as you probably already can see, a very small portion of this case. The court recites 2 black letter rules, one for intent and another for what constitutes an act. Okay? So we know, based upon this case, that a defendant intends a tort if he either consciously desires the physical result of his act, however likely that result may or may not be, or 2, is substantially certain that his action will produce a particular result, however much or little he may subjectively desire that the result occur. Now, that language is lifted almost verbatim from the case. It's tweaked a little bit just to be clear, but we're saying the same thing. And it's written in such a way where I can use this definition of intent as a topic sentence in a paragraph in an essay exam very easily. I can riff off in a fact pattern as a topic sentence for a paragraph. A defendant intends a tort if he consciously desires the physical result of his act, however likely that result may or may not be. Boom, I've got a topic sentence. I'm now ready to do factual analysis on that definition of intent. So we've got 2 rules for intent here. We've pulled them out of the case, And we're ready to plug those rules into an outline, defining intent. We've also got a rule for an act. A defendant acts when he makes an external manifestation of his will that produces consequences. This is why involuntary movements like flinching, convulsing during a seizure, or reflexively jerking a knee do not constitute acts. So here we got another good definition that we've lifted almost verbatim from the text of the opinion. And those are really the only black letter rules that we actually get in this case. So we've answered our first question, what black letter rules, and we got 3, 2 for intent, 1 for an act. And now we need to ask the second question. What inferences about the facts does the court incorporate into those rules? And really, the universe of facts that we have are those that the plaintiff alleged in his complaint. Okay, so what were those facts? He alleged that his coworker operated a garbage truck without a working horn, that he disregarded mechanical and electrical maintenance standards, that he failed to keep a lookout, that he failed to see what he should have seen, that he failed to stop in a safe place, and that he failed to warn plaintiff of danger. So here's the problem. Do any of those facts in and of themselves suggest or even support inferences that plaintiff's coworker wanted him to get hurt, or that his coworker knew that these activities would effectively guarantee his employee got hurt? Whatever risk that might have materialized was the employee undertaking what he was doing while that risk was apparent. So that's really the problem here. It doesn't seem like that's the case. These facts, as alleged in the plaintiff's complaint, all seem to bespeak maybe carelessness or inattentiveness or obliviousness, sure. But they don't bespeak a subjective appreciation of a clear and present danger to the plaintiff and a conscious desire to persist in a pattern of conduct that will guarantee plaintiff gets hurt. It doesn't even seem like coworker driver even knows that plaintiff will for certain be hurt, right? The risk didn't materialize until it was too late to anticipate. So any argument here that the defendant wanted or that coworker wanted this injured employee to be hurt doesn't seem like it flies. Any argument that there was some material risk that's so open and obvious that not only should coworker have known, but coworker did know and proceeded anyway, like that just doesn't seem to apply here. These facts won't cut it. All right. So, at any rate, these facts clearly don't support inferences about intent. They're the kind of facts that paint a strong picture of what coworker should have known, maybe if he'd been paying closer attention to what he was supposed to be doing, but not that he actually knew plaintiff would get hurt or actually wanted him to get hurt. So that's question 2. Now we got to deal with question 3. Who got what? And in this instance, defendant coworker got plaintiff's tort case against him dismissed. So even if it weren't clear to you from the analysis of the rule of facts that we've already done, you could deduce that plaintiff failed to make a valid intentional tort claim from the fact that the court applied a rule for intentional conduct to the case and then affirmed the trial court, which was the court that dismissed the plaintiff's tort lawsuit. So that technique can be quite useful when the reasoning is not as clear as it is in this case. So that's it for this exercise, guys. We hope you found it as useful as our students have. As always, don't forget to hit those like or subscribe buttons so that you can see any new content we publish as soon as it drops. And in the meantime, tell us how you did on the problem in the comment section below. If you drink from the keg of glory, then please regale us with tales of your exploits. Also, for those of you who like the content that you've received here on this channel but want to take your law school game to the next level, you can do that by visiting our website, kicklawschoolsass.com, and scheduling a time to speak with one of our coaches completely free. As long as there's a time slot available, we'll gladly talk to you about some strategies you can use either to enter law school prepared to kick its ass from day one, or if you're already enrolled in law school, to identify the key aspects of your experience thus far that you can fine-tune to elevate your performance. In any event, our only goal is that those of you watching these videos can take what you learn, apply it to your experience in law school, and kick its ass.
Kick ass.